Larry, we've had many people over the past number of years, especially with the rise of bifurcation, where clients would call me and be like, I just got contacted by U.S. Trustee Office on disgorgement of the fees. Oh my goodness. And
Mm,
that came up a lot with bifurcation, right?
right.
We've all experienced that. We saw the pendulum of bifurcation go from, two firms, Clark and Washington. I think it was Debt Stoppers in
Chicago,
Chicago.
Chicago, and yeah.
And they had this
Atlanta.
moat around them that they were the two firms doing it. And then it opened up with factoring. A lot of people started doing a true no money down. And then it slid back to, I think I have one client, he happens to be on the call today, that still does a true no money down bankruptcy,
hmm
not taking the filing fee, nothing like that. So a lot of letters. You get notified by the local trustee on whatever it is. What's a recommendation? What's the first thing you think about?
Well, there's a lot to unpack there, Phil.
Yeah,
Maybe we go back just a hair and talk
sure.
about the history of bifurcation.
Okay.
So after BAP-CIPA, and then there was a case, a Supreme Court case back in the early 2000s that really wasn't even a Chapter 7 case. It was a case that converted from an 11 to a 7, and then the debtor attorney was trying to get paid out of the Chapter 7. Those were the facts behind what
Mhm.
really screwed this up for the debtor bar
Mhm.
and for Americans who need relief. And the Supreme Court said, look, Chapter 7 fees pre-petition, or in this case, pre-conversion, are dischargeable like any other debt, the attorney fees. Well, if the attorney fee is dischargeable, then there's no way that you can get paid up front if the debtor doesn't have the money, right? So this was a creation of that problem, and it was very creative. Some folks out in Utah, one of my partners, Sean Mooney, as you know, started a company called BK Billing, and they went out and started bifurcating cases in Utah, and then they had a funding company that did that. And there was no, it was like the wild, wild west.
Yeah.
320 judges, 300 opinions, literally, on bifurcation.
Yeah.
And the problems were things like bifurcation itself, splitting this retainer into pre-filing work and post-filing work. So is it really pre-filing work? I mean, the program took the position early on. How could you possibly file this Chapter 7 case and know it's a Chapter 7 case if you haven't done all of the work to prepare all the schedules on the backside of the
Yeah.
case? That was their problem.
Mhm.
And then as far as getting paid post petition side, there were all kinds of problems there. And there are ethical problems involved, right? So this whole thing has evolved. The bottom line is today, the US Trustee Program has stopped fighting bifurcation. The bar is pretty set on areas where bifurcation is acceptable and areas where it's not acceptable. And where it is acceptable, the US Trustee Program has said, fine, we're not going to object to people who are doing bifurcation, but we still have concerns that are consumer protection concerns about bifurcation, and particularly if you're getting funding.
If the Chapter 13 U.S. trustee has said, we're not investigating bifurcation, why are there all these different bars around the country where I can bifurcate, I can't bifurcate? I hear it all the
Well,
time. I'm just curious.
yeah. Yeah, right. So it's not the 13 trustee, but it's the US trustee. And
Okay.
basically
Thank you.
what has happened is in places where people have tried bifurcation, opinions have been written. There's
Mhm.
great opinions out of Florida, great opinions out of Texas, Georgia, Arizona, California, Kentucky, Texas, Indiana, a lot of places where judges have opined and said, yes, Utah, this is a very acceptable way of providing legal services to debtors who can't afford to pay what today is like the average fee is like $2,200 up
Yeah.
front. I love that conversation. The debtor comes in, you explain the process, they're all great, let's
Yeah.
go. And the debtor attorney says, all I need is $2,200. So, like, what part of bankruptcy don't you understand?
Yeah.
Right.
Right. Yeah. Yeah.
So that's why bifurcation was created. There are other places who have looked at this and said, no, just on an ethical standpoint, you cannot bifurcate. And those opinions run various different themes that we could go through, but they're themes that have ethical tones to them with regard to the attorney client relationship
Mm.
that make them, those judges did not want to bless the practice. They also didn't want to bless the idea that they might have bought into the program's argument, which was you've really created a legal fiction. How
Okay.
could you have known this was a seven if you didn't do?
What percentage of the states was bifurcation sort of like
I
less,
think
more or
I'd
less,
pass
more
a
or
list.
less? Would
It's
you say
hard to say,
would you
Phil.
say
It's more,
50% or like of the
no,
districts?
I would say it's not based on the districts. I would say as a percentage of filings. There are a
Uh-huh.
large percentage of filings that are in states that allow bifurcation.
Got it.
But I would say there are probably just as many that don't. Yeah, maybe I don't know, Phil.
Maybe
I
it's
haven't looked at
50.
it lately.
It
Yeah, maybe.
it doesn't matter. This wasn't a call on bifurcation, but it is a
Right.
call on getting a letter from a trustee, the trustee.
Yes.
And
Yes. If
and
you,
and what does that look like? We get a call. So what would people get notified by, and why would they be needed to discharge fees and what that type of thing?
yeah, so it's not just related to bifurcation, but this gets back to what we were talking about is there is this regulatory body out there and it is the United States Department of Justice. For real. They have a lot of power and it can be very intimidating. And whether it be bifurcation or whether it be anything else, they may start to take a look at what you are doing in your practice. They may have a reason to believe. Now, on the bifurcation side, I give you a specific example. They might want to interview the debtor. They'll say, "Hey, we want to talk to your debtor." Don't ever let your client talk to the U.S. Trustee Program without you being present. And unless the program can really demonstrate for you a pretty good reason, if you have any concerns, you might want to push back a little bit and flush that out a little bit. Now, clearly the program can. The program is a party in every bankruptcy case by statute. So they can use Rule 2004 like anybody else can to interview the debtor and get information about this filing. And so that you really can't stop them, but you want to be disciplined about it. Maybe they want to ask the debtor, when did you sign this pre-petition agreement?
Mhm.
When did you sign the post-petition agreement? Did you go in person? Are these your wet signatures each time you went?
Mhm.
Because debtors might take shortcuts. They haven't signed both agreements before, they file one and then they file the second one. Well, when did you sign these schedules? When did you sign the SOFA and the other schedules? In a bifurcation, as you know, you're filing a skeletal petition, right? And the statute allows this to allow for an emergency filing. They don't all have to be emergencies, but you're filing, somebody needs relief now. Name, social security number, who are your debtor, who are your creditors, but a couple pages, you file it, boom. You get the benefit of the automatic stay in the bankruptcy code. That
Right.
is next to the discharge, the second biggest thing that happens, and you get it immediately. Think about this, Phil. Think about this. If you were to ask any of your lawyers, how hard is it to go to federal court and get a temporary restraining order on the signing of papers? In every instance except bankruptcy, it's a
Yeah.
hell of a lot of work. In bankruptcy, you get it just by filing these two pieces of paper.
Oh yeah,
So
yeah, yeah.
there's a lot of weight on the integrity of what you're doing,
Mhm.
right? And
So
then you're filing the back half.
right. So,
Right.
but I think this is played out. I think bifurcation, people who bifurcate, they know they bifurcate. They feel comfortable.
Hmm.
People who don't are not. I don't hear it the same way I used to, right? Like people either love it or they
No,
don't.
it's for the most
But
part a settled issue now, I
yeah,
think.
but let's talk about just you get a letter from a U.S. trustee for whatever reason, not bifurcation. Let's move that to the side. What do you do? What don't you do? Like you currently, Larry Friedman, you've represented multiple people recently with the U.S.
Yes.
Trustee Program. Give us an example of like, obviously without giving any specific information, what are people being investigated on and what do you recommend they do, right? Like
Yeah.
what's the first step when you get a letter?
Well, the first thing you got to do is engage with the program. I
Mhm.
would call, if I got an inquiry, I'd call the staff attorney who sent me the inquiry and I'd say, look,
What's going on?
is this an issue with this client? Are you concerned about something with my practice? I
Right.
mean, they're not, they'll talk to you. They should talk to you.
Mhm.
Oftentimes, it's not the inquiry. It may be that you've been practicing for a number of years, and for whatever reason, the program has the impression that there are things in your practice which are sloppy or which are not, locked down enough. and these can cause consumer protection issues.
Mhm.
And they get this information from trustees
Mhm.
sometimes. Chapter 7 trustee, you may not have a problem with the trustee, and then something comes up, and then you go to the program, it's like, this guy has been a problem for years.
Mhm.
Well, that tells you everything.
Right.
They've been getting fed information for years
Right.
about your practice,
Yeah.
and they just happen to look for the right opening to say, we're going to take a look at this guy.
Yeah, this is not something that happens overnight. These are practical sloppiness, non-process driven, as you talked about, focused situations that's happened over the months and over the years. And they're like, okay, let's send this guy, let's do an inquiry. And when
That's
they
right.
do an inquiry, they may be looking at the practice, but it'll maybe be dialed in on a certain case, but opens up more, right?
And what they've chosen to hone in on may not be the greatest case in the world, because I've
Mm.
had a couple of these settle where basically the program folded, for basically a disclosure issue. But they got out of it, hey, you're under the microscope.
Yeah.
It's all these other things. And then those people now are working to clean up their practice. It's that the settlement may settle the one adversary proceeding and the motion to disgorge fees. But what you really have then is you need to build a relationship or build a resolution with the program that shows that you're doing whatever caused them to start the inquiry. You want to address it and say, no more.
Yeah,
And we're going to
absolutely.
solve it
Yeah.
this
So,
way.
so that's a win for the trustee program because
That's
they're
right.
getting more process out of the debtor firm. They're getting less
Consumers are
sloppiness
getting served better.
and service, and that's
They
really
would they
important.
would say.
Now, is there anything a debtor attorney should do like proactively? I mean, besides what we talked about, obviously, you don't ever proactively talk to the program, right?
No, but the program participates in local bar events and dinners and things like that. You shouldn't, don't be afraid to go introduce yourself and talk
Yeah.
to these folks. And they're they're attorneys and staff people and analysts like everybody else. They just happen to work for the Department of Justice.
I find it interesting you didn't say when you get a letter, hire counsel to send a letter. You used to call them up
It, it,
and
it
say what to.
depends. It
Yeah.
depends. I think you have to ask initially, what is this about?
Yeah.
And if it's about this one case, we're just concerned about this, well, then we can resolve this. But if they're like, well, we have a lot of things we want to look at. If
Mhm.
you get a very vague answer and they still want to proceed, then you need to call counsel.
Got it. Got it.
And you need to call somebody who understands the program. We represent debtors, creditors. I mean, creditors have problems too, right? Claims that they filed that weren't properly flattened.
Mm.
And so they violate 9037. There are all kinds of things that all parties in bankruptcies have that can trip them up with the United States Trustee Program. And what Friedman Partners does is represents parties before the program in resolving those issues.
And how often do fees actually get disgorged? Does that happen often?
I wouldn't say it's often, but
Yeah.
it can happen, and it can happen big.
Yeah.
If there's something in your practice that has been going on for a long time that just happens to be wrong, if you react in the proper fashion, you can it's a negotiation, right? But if you are like, that's bullshit, I didn't do that, that's crap, I didn't do that, I didn't do that, right? I'm fighting all the way. You better be prepared to go the distance. I
Yeah.
remember clients coming to me say, I didn't do anything wrong and I want to clear my name.
Yeah.
Well, or I want justice. Most people can't afford justice, even
Yeah.
lawyers, because it
Yeah.
costs a lot of money. What you want is a resolution.
Yeah. That's for sure. Good. Okay, so I got some questions here. James Howson, one of our great attorneys from Ohio, said, "Why did the U.S. trustee program in one region think attorney fees are reasonable and not in another
Mm.
region?" James, you want to expound on that at all?
In the Northern District of Ohio, I can charge $2,000 for a Chapter 7 for a Social Security case, and it's a no asset case, but there's still the same amount of work you have to do, your due diligence, like you were talking earlier about, like there's sloppiness, and we don't put up with sloppiness here in this firm. And then I filed a case down in Southern District of Ohio,
Like
and this
Dayton,
guy, what's that?
like Dayton, maybe.
Well, yeah. And the guy gets Social Security, $1,864 a month. Yes, it's an no asset case, but I had to still do my due diligence and ask all the right questions. And the U.S. trustee comes back at me and they're saying, well, the attorneys down here only charge like on the average $1,000. So we believe you should disgorge $1,000 of your attorney fees plus 338 of your filing fee because he would have qualified for a fee waiver. When in reality, all they're doing is that they're trying to chase people out of the Southern District of Ohio who are competent, who can't be able to earn a living by operating a law practice. And it just seems like it doesn't make any sense to me why they would be doing that. Why
Yeah,
is
so
North District's okay, Southern's not?
yeah, James, it's a great question. I actually was involved in a matter up there on this very issue in that region with the program that sought disgorgement of thousands and thousands of dollars of fees. This is the example I was talking about, where the attorney was charging 1,900, 2,000, 2,100, and the program was like 1,100's the number. Well, first of
Yeah.
all, the government should not be in the business of setting fees,
Mm.
and I don't think they are. After, you know, thousands and thousands and tens of thousands of dollars of litigation in this matter, which I got resolved, what it turned out was, in my mind, they never acknowledged this, but I am certain I'm right. There is a judge out there in that district who I think is going to retire this year, who I think, and this happens, was getting the program to do his dirty work for him. He didn't want to be the bad guy. So he somehow raised this issue and then asked the program to investigate it. And now all of a sudden the program's like, oh, this judge wants this issue. We can get a lot of points with the program by, digging up these cases. And it arose out of the Southern District, I think, way south, where people were charging, I think they still are like $1,100, maybe 900, 11,
Yeah, they're charging
1,200.
eleven hundred
Woman down there,
dollars.
11.
Yeah.
And it's like, I don't know what they're doing, but that's crazy. And and I think that things like that ought to be taken on. And the way you do that, I think, because it's hard to just go up against the program and the judge, especially when the program is doing the judge's dirty work for them. You got to look for the right case. You got to bring it in at the right time frame, and you have to build it in a way that you can demonstrate the amount of work and actually put a time factor on every single task. When Chapter 7 trustees in the 90s started, the no asset fee was $35, right? I think it was 30, it went to 45 and then 60. And we were in Washington lobbying Congress on getting this fee increased. And I sat down with, at the time, the Speaker of the House. And he said, former Speaker of the House. And he said, explain to me, Larry, what you're talking about. I mean, it seems like tidbits. What are we talking about? And I said, I get assigned a case. The program sends me the schedules. The court clerk sends me schedules. The program sends me a letter appointing it. I have to open a file. Admin has to label the file. I have to track that file for 3 years. I need file cabinet space. And I went through in microscopic detail every single thing I had to do or any trustee had to do to administer that case and put a value on it. And then he was like, this is stupid. Yes. If somebody wants to take on the effort to build that kind of a case, I think you could overcome that. But I think what you're talking about in that jurisdiction is unique to that jurisdiction. I don't think U.S. Trustee Program offices around the country are doing that. That's why I know it's the judge's dirty work, because it's not a program initiative. And they know that they're not out there to set fees. What they're doing is bringing these cases to light because the judge doesn't think that debtor attorneys doing 7 work ought to get paid anymore.
So Larry, what does James do? Does he just avoid Dayton?
There are several ways to solve it, but what will work there, I'm certain of it, is if you file the case and you keep detailed time records on every single thing you do. And when they send you a letter saying, hey, we think this fee is too much, you send them back the time records and say, really? I talked to the guy 27 times. Took me 15 phone calls to get him into my office. I had to go out to his house to get a picture of his car. Whatever it was, do the things that you do because we know it's a ton of work. I mean, I want to, sometimes I want to take somebody like this attorney, but in particular this judge, and take him out and show him what's involved in putting together this bankruptcy petition, because I don't think they get it. They think someone sits down, you put in a bunch of data into a piece of software, spits out a petition, file it, bing, bam, boom, 2-minute hearing, debtor gets a discharge. Why does that cost a lot of money? Because there is a lot more to it than that. So in every case, I would charge your fee of $1,800, $1,900, $2,100. And every time the program says, hey, James, we think this is too much. Say, really? Here's my time slips. Matter of fact, case I resolved, as he's filing cases, he's sending the redacted billing to the program, not another call.
So he's still charging obviously more than
Yeah.
1,100. And so
Now,
when
to
the
be
judge,
fair,
yeah.
if it is Social Security disability, if it truly is, James, a simple case, he's probably stuck at like $1,600. But there is a way to combat that, and you can do it. And I use a software time billing system called TimeSolve. It's off the shelf. It's very simple. It's very cheap, $50 a month, and it's very good. Put everything in there, print that thing out, send it to the program, and say, here, you want to know what I did in this case? Here's what I did. Any more questions? No. End.
Larry, let's just pretend the judge retires. Do you just go back to normal, or do you
Well, I would keep.
contact
I
and
wouldn't
say,
look
hey,
for a. I would look for a fight. If I have a system that's working and I'm getting my $1,800 or $2,000, I'd use it. But you could always bring a case with a new judge and a motion to approve your fees. Get the right case. Make sure you've done the work. Make sure you could document the work, and then file a motion to approve the fee.
mhm.
Now, who's going to object? U.S. Trustee Program. If they don't object, you're good. And if they do object, I think you're going to prevail. And when you prevail, end of problem. Because they're not going to waste their time if they're going to get their head beat up by the judge. But that's going to take a change in judgeship up there, I think, for sure. If you really
Well,
want to
actually, this is in Columbus. It's a new judge down there in Columbus. But what they're doing is that gave me an order that it got against recovery law, I think it's called, back in 2022. And they're showing that order of why I should have to disgorge my fees. Now, they've been threatening me since early last year when I first filed my case down there in Southern District. And I kept on hitting them back that here's all the work I do, here's all the work I do. And they threatened me before, but they never before did they show me an order from recovery law and say that we're going to file a motion to disgorge your fees if you don't do this. And so this is the first time they're actually doing this to me. And I think they're doing this case because it's a Social Security disability case.
Yeah.
I think that's right. They're looking for the low-hanging fruit. What's he going to say about this? So if the case is truly a very simple case, I don't know, give the debtor back $300. If you want to have this, if you want to tee this up, get the right case, hire competent counsel, and we'll tee it up and see what happens.
Okay.
It costs a lot of money. My client in that case spent 5 figures
Wow.
getting it fixed.
So when you say 5 figures, is that like 10,000 or is that like
More than
20,000?
more than 10,000. More than 10,000.
Less than what? 30,000?
Yeah.
Okay, so it's around 20-ish thousand for that. Okay.
It depends on the battle.
60 bankruptcies a month for 3 years, it more than pays for itself by many, many multipliers. You're never going to
Bill, if you're doing 60 a month and you were off by $1,000 a case, it's $60,000.
Yeah. But the practicality is they're not going to go back and disgorge hundreds of cases. They're gonna, yeah, but you start going back and everything I've heard with it, you go, I mean, as long as there's no fraud and there's not any type of,
You're not going to end up disgorging in that situation, but yeah, I mean, don't think that they can't do something. They
no,
can,
well, no, of course, it's the benevolent dictators, right?
And like Jim says, it's threatening.
Yeah,
it's threatening your practice.
Oh, I get it. James, thank you.
What you want to do, this is a perfect example that Jim gave up. He didn't do anything wrong. I don't know who's got whose bug up whose butt, but that is a situation that needs to be resolved.
You have this consulting firm where you represent firms like this, like our debtor attorneys with the trustee program. And this is just basically something people can hire you, retain you to sort of like navigate the complexity of the whole thing, right?
Yes. I'm pleased to say that we've resolved them all. We have not tried one yet.
Larry, thank you for your time. Thank you for your interest. And thanks for all you've given to the bankruptcy debtor community. And we will do more.
Love to. Thanks so much,
Larry.
Phil. Appreciate it.
Thanks, everybody.